Hello, respected viewers. So this is my English law channel, and I'm talking about offences against the person. I'm now going to examine the defences against charges of offences against the person. So, supposing you are the defendant, you're the person who's been accused of using unlawful force against another person without consent. Well, how could you successfully argue that it was acceptable for you to use this force? Okay, so we'll look at various issues, including intoxication, which as we'll see is seldom, if ever, a defence. We're also going to look at consent and when these so-called defences really are valid defences. So intoxication is usually meaning being drunk, but it could be under the influence of medicines, under the influence of narcotics. That's not going to be a valid excuse. All right, so this is how people try and use it as a defence. So the defendants can say that yes, he was intoxicated, so under the influence of something which meant that his mind wasn't functioning properly. Therefore, even if he carried out the act, he didn't have the mens rea. So yes, he performed the physical action, but he didn't have the guilty mind. He wasn't in control of himself. He didn't know what he's doing. It's a bit like automatism. So those are against porridge, not that kind of porridge, but P-O-R-A-D-G. And the question is whether the defendant in this case really had the mens rea. Was he even able to form the mens rea? Arguably not. Or a case called R against Kingston. Now, this is where people had to try and tell apart whether someone had the mens rea anyway, and just intoxication meant that he acted on it, that they then performed the actus reus. Because whether you're inebriated or not, intention is still intention. All right. So some people. So the reason that it doesn't work at this defence of intoxication, voluntary intoxication, if you chose to consume spirituous liquor, or you chose to take illegal drugs, or to take medicines unnecessarily, well, a defence of intoxication shan't lie. I think it was as Aristotle said that a drunken man who does something foolish deserves to be punished twice, once for the foolish thing and the other one, and also for being drunk. So don't get yourself into a crapulous state. You're still answerable for what you do. I mean, imagine if drunk drivers could get away with it. Well, yeah, I crashed and killed someone, but I was drunk, so therefore I can't be held to account for it. No, you are answerable for that. So voluntary intoxication is of your own free will, consuming alcohol or unlawful drugs or medicines that you do not need. Now, involuntary intoxication is where you take medicines that you do need. And okay, yes, it was your choice, but because it was a medicine that you required, therefore we regard it as involuntary. And if that medicine that you took, that you actually needed, caused some sort of derangement of mind or whatever, which led to committing a crime, then you shan't be held responsible. Moreover, if somebody actually put drugs or medicine or alcohol into your food or drink, had you take them, forced you to take them, if you were taking these things without your knowledge or consent, in that case, that's also involuntary intoxication, and that could lie as a defence. So R against Allen is a case of involuntary intoxication. Anyway, it can involve taking illegal drugs. There's Department of Public Prosecutions against Majewski, and the Majewski rules came out of that. And these tell apart crimes of specific intent from crimes of basic intent. So intoxication can be by non-dangerous drugs, as in things that are prescribed or things that are purchased from the pharmacy without prescription. So this could operate as a proper defence to basic intent crimes, as well as specific intent crimes. R against Hardy is a case in point. So, in specific intent crimes, it can be used. So basic intent crime, well, the question here is, was the defendant reckless in taking that drug or not? So there's voluntary intoxication. Well, let's consider basic intent crimes. If he was reckless in imbibing alcohol or taking some illegal drug or some medicine they did not need, the mens rea is proven. However, the jury will be asked to consider if the defendant would have perceived the risk had he been sober, clear-minded, as in not under the influence of any psychotropic substance. Okay, so the Judicial Studies Board Crown Court book directs people to use about using the second method, about when the jury has to consider whether the defendant would have perceived the risk if he had not been under the influence of any intoxicant. And there's a case about this which is R against Colin, McGee and Harris. So what impact does intoxication have on other defences? Well, we'll have to look at consent, but I think we'll come to that next time. Self-defence, likewise, next time. It can also lead to a loss of self-control or diminished responsibility, and that particularly impacts murder. So there's a defence to specific intent crimes, for instance, criminal damage. Criminal damage is destroying or else injuring some substance, as in some substance, some item, not a human being, a car, a window, a jacket, a flower bed, anything like that, items of furniture, so non-living objects. If you burn them, you smash them, you tear them up, whatever, that's criminal damage. So there's the Criminal Damage Act 1971, but we'll look at that later. So consent. So consent is a defence. So they can be used as in the person that you harmed, that you slapped, that you kicked with, you hit with a stick or whatever. If he or she wanted you to do it and said, yes, please do it, you have my permission, I want you to. It could be part of some sadomasochistic orgy or something like that. So you might say there was no mens rea in that case. Remember, volenti not fit inuria. There's R against Brown. But there's obviously a burden of proof issue. Remember, the onus is on the defence in this case. So generally speaking, it behoves the prosecution to prove their case. But if you're going to raise a defence of consent, then it's up to the defence to prove that there really was consent. Okay. So, the prosecution may contest that there really was consent, but especially a binding consent. A drunken consent or a consent of someone who was effectively overborne would not operate. So, moreover, if you honestly believe there's to be consent and it's reasonably held, you believe the consent, then that could still be defence, even if it turns out that there actually wasn't consent. I believed he wanted me to do this, and I had a good reason to think so, so I hit him. Actually, it turned out I was wrong. He didn't want to be hit, but because it was a reasonable belief at the time, and I truly believed that there was consent, in which case there'd be no mens rea. Okay, so it's possible to consent to have this thing done to you, but only up to a certain limit. Very serious harm can't be consented to, just like being killed. I mean, that consent wouldn't count. Okay, so there's either actual consent or an honest belief that there was consent. A mistaken belief in consent might be induced through inebriation, such as in R against Richardson and Irwin, in which case that defence shan't operate. So what is the general rule here? Well, Attorney General's reference number 6 in 1980 dealt with this. So the Lord Chief Justice, Lord Lane, he's the one who propounded on this one. He said, it is not in the public interest that people should try to cause or should cause each other actual bodily harm for no reason. So courts are hesitant to accept a defence of consent. Yes, they will sometimes accept it, but do we really want people going around slapping, kicking, punching, hitting other people with sticks, whipping each other or things like that? Even if someone says, yes, that's a good thing, because think of what the effect is on society. A lot of people getting injured and then have to go to hospital, or their injuries go a bit too far, get killed, or we get so enthused about inflicting physical harm to each other that we might think there's consent where there actually isn't. So really we want less violence in society. So the House of Lords upheld that Lord Chief Justice Lane's dictum in R against Brown. So one can consent assault and battery, and that defence will lie, as in it will exonerate the defendant, as in R against Meechan. So coming into Meechan, I think it's pronounced Meechan, not Meechan. In this case, the defendant didn't perceive the risk of causing harm, so therefore the defence operated. So this is true regardless of how severe the harm was going to be or exactly which activity one was engaged in. However, where a defendant does not intend harm but does foresee the risk of harm, the Court of Appeal did not say whether that defence would work or not. Now, if the defendant wishes to cause harm, the defence is unavailable. It won't work unless it's one of these very narrow exceptions, such as in R against Brown. Medical treatment being one of them, because in medical treatment, you might be performing an operation, you're cutting the skin with a scalpel or whatever it is, or you're taking blood out of somebody. That's physically harming someone, but this patient has consented to that. So that's not malicious wounding. Now, supposing you're a doctor or nurse and you believe that the patient's consented, you're doing this for the patient's own good. And so you break the skin, you draw blood, whatever it is. But then it turns out you were mistaken. The patient did not consent. So therefore you've committed a rather serious offence. But so long as you honestly believed that the patient consented, then as a doctor, nurse, or dentist and so forth, you're in the clear. You'd be acquitted. All right. There are other exceptions in sport. Like Aaron Barnes thought about this. What sport are we talking about? Are we talking about tennis? You shouldn't be hitting each other there, right? The ball might accidentally hit you. Or we're talking about boxing. So some sports are contact sports, and they get necessarily contusions and occasional drawing of blood shall be consequent upon engaging in such sport, which necessitates plenty of rough and tumble. And which level is the sport played? If it's a group of 5-year-olds, then they're going to be gentle with each other in their special rules, so that there's not going to be too much collision. And what act was being performed? For example, in rugby at the kickoff, we're just kicking the ball. I mean, that doesn't mean you're allowed to punch someone at that moment. Or are you tackling someone when you're going to grab the person is going to fall to the ground? So you'll be slightly hurt, both of you. And what force was used? I mean, remember in a handoff in rugby, you have to go like this: the open palm, the fingers together and upright, because it can't be like that, because that's like getting you in the eye. And the thing is, if the fingers are not together, there's a higher chance one's going to get in the eye, and can't be slapping. So have to push here and then push away. Get with a straight arm, not because that's almost punching somebody. So anyway, and then an injury will result sometimes. And how great was the risk of this? What was in the defendant's mind at the time? Did he want to cause this person as much harm as possible? Or was he playing within the rules to get the ball? He was playing in furtherance of the objective of scoring goals or whatever, or scoring a try. But if we think that his principal aim was to cause physical harm to the other, then that's more likely to be assault. R against Billinghurst also considers this issue. So anyway, if somebody's charged under Section 47 of the Offence Against the Person Act, because it caused a sporting injury to somebody, would the consent defence work? It probably would in rugby. In football, depends what they've done. I mean, slaps or kicks, no, because it's not. Slaps or punches, no. If you kick someone in football, well, you might have been missing the ball. As long as you're going for the ball, I think that defence will work. Now, there's also horseplay, so some physical play, some physical contact at a low level, we think that's acceptable. In R and Jones, R and Aitken, R against Richardson and Irwin, these play fights, they get out of hand occasionally. Now, personal adornment, body art like tattooing and so on, piercings, those are acceptable. The person's 18, compos mentis and so on, you're licensed to do it. R against Wilson decided that. So So there are various cases about sexual gratification, accidental infliction of harm, R against Brown, R against Decker, where someone he was HIV positive, he knew this, he had unsafe sex with a number of females, not informing them of his HIV status, and at least one of them contracted human immunodeficiency virus from him, and that was held to be a serious crime. He went to prison for a few years to that. So if he'd used a prophylactic with her, he would have been clear. Even that burst had torn and she'd contracted HIV, he would have been trying to prevent her catching the disease. Or indeed, if he informed her of HIV and she agreed to have unsafe intercourse with him, if she passed on to her, no, that would be in defence of consent, because of course it's not certain that she'd catch it, even if they had unsafe intercourse 10 times. Okay, so but if she's choosing to expose herself to risk of getting HIV and does indeed get it, in which case he's in the clear. There's R against Slingsby, where this man, he was engaging in sex acts with his girlfriend, and he had a ring on his finger, and he digitally inserted into her vagina and anus, but that ring cut her, and septicemia resulted, and she died. Well, he was engaging in a consensual activity with an adult, so even though it led to her death, he didn't wish to cause her any harm, so he was not found guilty of anything. The other cases are in Boyer, R and Emmett. So we know that everyone knows they can catch sexually transmitted diseases and so on. All right, so that's enough about Offences Against the Person Act and various defences. Goodbye.